Avery pretrial motion. State of Wisconsin, Circuit Court, Manitowoc County, Branch 1. State of Wisconsin, Plaintiff versus Stephen A. Avery, Defendant. Jury trial, Day 5. Peremptory strikes and motion hearing, Manitowoc County. Motion hearing, Calumet County. Case number 05CF381. Date, February 9, 2007. Before the Honorable Patrick L. Willis, Circuit Court Judge. Appearances, Ken Kratz, Tom Fallon, Norman Gunn, all special prosecutors on behalf of the state of Wisconsin. Dean Strang, Jerome Buting, attorneys at law on behalf of the defendant. Stephen A. Avery appears in person. Transcript reported by Dan Teskis, official court reporter. Appearances, Peremptory strikes, motion hearing in Manitowoc County, proceedings in Calumet County, motion hearing, and witnesses. Trooper Tim Austin. Direct examination by Attorney Kratz, cross-examination by Attorney Strang. Arguments to motion. The court. At this time, the court calls the case of State of Wisconsin versus Stephen Avery, case number 05CF381. Will the parties state their appearances for the record, please? Attorney Kratz. Good morning, Your Honor. State of Wisconsin appears by Calumet County District Attorney Ken Kratz, appearing as lead special prosecutor in this case. Also appearing on behalf of the state is Tom Fallon, Assistant Attorney General with the Department of Justice, and Norman Gunn, Assistant District Attorney from Milwaukee County, also appearing as special prosecutors. Attorney Strang. Good morning. Stephen Avery is here in person, Your Honor. Jerome F. Buting represents him to my right, and Dean A. Strang. The court. Very well. We are here this morning to complete the process of jury selection. The remaining members of the jury panel are now in the courtroom. At this time, the clerk will call the jury panel members by name, and the jury bailiff will show the panel members where to be seated. The clerk. Daniel Slavy, Diane Free, Terry Timme, Jacqueline Ungrot, Sherry Haskell, Barbara Schmidt, Sharon Thorne, Julie Dorn, Paul Nilsson, Nathan Klein, Philip Sari, Michael Stonebreaker, John Lawrence, August Schutt, Marion Flint, Kevin Brodsky, Richard Muller, Tammy Goss, William Marr, Patrick Keenan, Melvin Pedersen, Henry Gray, Nancy Steinmetz, Mary Lou Solomon, Carl Wadman, Laura Barber, Scott DeFer, Donald Kickland, David Guckison, Patricia Piaskowski. The court. Members of the jury panel. As I explained last week, now that 30 qualified jurors have been identified, the parties will be exercising what is known as peremptory strikes. Each side, on an alternating basis, is permitted to strike 7 members of the jury panel. 16 remaining jurors will hear the evidence in the case. At the conclusion of the trial, the names of the alternate jurors will be drawn by lot, and 12 jurors will deliberate and render verdicts in this case. The parties will now begin the process of exercising their peremptory strikes. The courtroom is to remain quiet until that process has been completed. Peremptory strikes made. The court. At this time, the court will read the names of the persons who have been selected to serve on the jury in this case. When you hear your name read, please stand. Daniel Slavy, Diane Free, Terry Timme, Barbara Schmidt, Sharon Thorne, Julie Dorn, Paul Nielsen, Nathan Klein, August Schutt, Marion Flint, Richard Muller, William Moore, Henry Gray, Nancy Steinmetz, Carl Wardman, Laura Barber. Those of you who are still seated will not be serving on the jury in this case, and your jury service in this matter is complete. On behalf of the Manitowoc County, I want to thank you for your service. I do have one final instruction to read to you before excusing you this morning. Your service in this case is completed. You do not have to answer questions about the case from anyone other than the court. There is no requirement that you maintain secrecy concerning your participation in the case, but you do not have to discuss the case with anyone or answer any questions about it. At this time, the court will ask that the jurors who are currently seated, those of you who are standing, can sit. The rest of you can stand at this time, and the bailiff will escort you to the jury room. Attorney Strang, Your Honor, there will be a motion that should be addressed before anyone is excused. The court, do you wish to do that in the presence of the jurors? Attorney Strang, I do not. The court, pardon me? Attorney Strang, I do not. The court, oh, okay, all right. Take them to the Branch 1 jury room on the other side. You can follow the bailiff. Excused jurors taken to Branch 1 jury room. The court, all right. As soon as the bailiff gets back, we will have the other jurors retire to this room. At this time, those jurors who have been selected to serve on the jury in this case may rise, and the bailiff will escort you to this jury room. They will be coming back out, Shirley. Jury bailiff, okay. Chosen jurors taken to Branch 2 jury room. The court will note for the record that the jurors are now in the jury room, outside of the courtroom. Mr. Strang? Attorney Strang, thank you, Your Honor. Outside the presence of the jury now, given the demographics of those approximately 90 jurors we saw physically from the panel and the state's use of one of its 7 peremptory strikes to strike Mr. Lawrence, I feel bound to make a motion to reverse that state peremptory strike on authority of Batson versus Kentucky in cases that follow. I will make the following record as a matter of prima facie showing. The highest sequence number juror whom we examined was number 90 by my count. Of course, there were a number of jurors struck by joint motion before we got to 90, so we didn't see 90 human beings here. But of those we did see over the last 4 days, one and only one appeared to be at least partly African American heritage, and that was Mr. Lawrence. I also noticed one other person who appeared clearly, at least to my eyes, to be not of European ancestry, and that was Huang Dao, first name Huang, last name Dao. Of those 2 people, only Mr. Lawrence was in the final pool of 30. As I say, I can't comment. I don't know his ethnicity or his parentage, but to my eyes, he looked to have at least one parent of ultimately African heritage. Describe him as light-skinned black man with a relaxed curl for his hairdo. The other jurors in the final 30 appear to be of what I will call European ancestry, that is, Caucasian or white-skinned in the vernacular. So I think there's a prima facie showing. I note as well that although the court ultimately found the cause for striking Huang Dao, Mr. Huang was a juror we sought to keep, and indeed, I think I wanted him held in abeyance, if nothing more. The motion to strike Mr. Dao was the state's. Again, that's a different matter in the sense that the court found cause, and I believe I acknowledge that, there was a basis for the state's motion for cause, and I recognize the potential issues there. I add only for the full context in moving to set aside the state's use of a peremptory strike against Mr. Lawrence as a matter of due process under the 14th Amendment to the United States Constitution and correlative provisions of Article 1 of the Wisconsin Constitution. The court, who will be responding on behalf of the state? Attorney Fallon. I will, Your Honor. The court. Mr. Fallon? Attorney Fallon. Yes, thank you. Actually, I find the motion rather stunning from counsel, very accomplished as Mr. Strang. Nonetheless, I have several responses, both legal, practical, and the like. First and foremost, the first step in any Batson challenge is that the defendant must show that he or she is a member of a cognizable group, and the prosecutor has exercised a peremptory strike to remove members, defendants' race from the veneer. So unless counsel is suggesting that Mr. Avery is of African American descent, that would be a new revelation to the state. And even if that were the case, I would indicate for the court that we seriously thought yesterday we were going to move to strike Mr. Lawrence for cause. We weren't as quite as certain as we were this morning, but we believe that Mr. Lawrence lied on his questionnaire. In fact, if the questionnaire is to mean anything, it's a significant question. We were uncertain because we wanted to verify as best we could, and we think we have, although nothing is 100% certain. But in answer to question, I think it's question 54, have you, any members of any family members or anyone close to you, ever been a suspect and arrested for charged with a criminal offense? First, we thought it was Mr. Lawrence himself who had been arrested, and he has a pending drug offense. But it turns out there is a John O. Lawrence Sr., age 44, whom we believe to be this juror's father, with a pending offense. In fact, he has a number of pending drug offenses. And he indicated no. And I believe he indicated that there was no contacts with law enforcement of any kind. And that caused us some great concerns. We were, last evening, working on the CCAP program and trying to verify as much as we can. But we believe this John O. Lawrence Jr. to be the son of John O. Lawrence Sr. with a criminal history. Would also indicate for the court that another matter concerned the state, and that is the youth of this man. And obviously, at the young age of 20, it's very hard for someone of that age to distinguish themselves in the community. But he did not impress us with a significant work history for any of that to suggest that he had a claim or a sufficient stake in the community relative to the deliberation process. But primarily, we were under the impression, based upon our information, that he was not truthful in his questionnaire, and quite frankly, he should have been struck for cause. We wanted to do our best to try and verify as best we can. Lots of phone calls late until last night, and we believe that is, in fact, related as best we can given the name and the same middle initial and the junior and what have you. As a result of which we have a legal basis that is not a Batson issue. 2, we have a juror who we believe lied. And 3, we have a demographics of he did not distinguish himself. He did not look to us like he would be a responsible, dedicated juror, notwithstanding the responses he gave. And those are our reasons. Hold on. Is there a concession that Mr. Avery is not a member of the cognizable class? Attorney Strang, Mr. Avery is not African American, and it has been established since 1990 or 91 by the United States Supreme Court in Powers v. Ohio that one need not be a member of the same ethnic group or other cognizable class as a struck juror to raise a Batson challenge. Powers versus Ohio, United States Supreme Court, if my memory serves even closely. So I think that lays to the rest entirely the first defense the state offers, which is the legal one. As to the factual defense, the juror questionnaires will be part of the record, but I recall nothing in which Mr. Lawrence offered his middle initial or his middle name. Now, whether there's a John O. Lawrence Sr., who is in fact his father, I don't know. My recollection is the juror made a comment about not knowing much about his father or not having much contact. And I don't remember exactly what he said, and I could be a mile wide there, but transcripts would bear that out. I do recall him listing junior on his questionnaire. I do not recall a middle initial. The court. All right. The court does not have the Batson test committed to memory. It's not something that gets raised very often. Mr. Fallon. Attorney Fallon. Well, there's a recent Wisconsin Supreme Court case I'm aware of, the Powers. There's a 2003 Supreme Court case, State versus Lamon, Lamon, setting forth the 3-step process as well as that could be examined. The court. All right. I'm going to take a short recess, and then we'll get back to the record. Before I do that, let me ask, as long as we're on the record, something I meant to ask earlier. Subject to the objection raised by the defense are the 16 jurors that the court has identified, the jury that each party selected based on the peremptory strikes. Attorney Fallon, I believe the panel left reflects accurately those which we struck by the state. Attorney Strain, so do I. The court, thank you. Brief recess taken. The court, at this time, we're back on the record outside the presence of both at least tentatively excused jurors and the jurors who have been tentatively selected to serve on the jury panel. The defense has made a motion challenging the state's decision to exercise one peremptory challenge for the purposes of removing a juror who appears to be of a minority race in this case. I'm not sure that the fact is disputed. That is, I believe that both parties recognize Mr. Lawrence would fall into the category of somewhat of a minority race. Attorney Strain, and I think so, but I was going to add one further factual agreement that we're able to come to, I think, during the break. I think that when we went back and checked, Mr. Lawrence did not list his middle initial on his handwritten questionnaire, but the middle initial O is listed on the computer printout voir dire list in the various sorts from the court. That's the one that the parties have dated as January 26, 2007. So the name is, as given on the questionnaire, is John Lawrence Jr. The name on the computer voir dire is John O. Lawrence, without a junior or senior designation, and that's at least agreed on the defense part. The court, all right. The first issue is whether or not a defendant wishing to raise a Batson challenge has to be a member of the minority class himself in order to do so. Based on the court's reading of the case law, specifically the Powers case, to which the court was referred, and with which actually cited in a footnote in the Lamont case, page 762, where the Wisconsin Supreme Court recognizes that a defendant of whatever race is entitled to a jury selected without discrimination by authority of powers. So I don't believe the fact that Mr. Avery himself may not be a minority, may not be a member of minority race, is sufficient to preclude the defendant raising a Batson challenge to the dismissal of the striking of Mr. Lawrence in this case. The court believes then that it is required to apply the Batson analysis to the case. First step of the defendant raising a Batson challenge is to make a prima facie showing that the prosecution has exercised a peremptory challenge on the basis of race. As I've indicated a minute ago, I don't believe that there's a dispute in this case that's part of the rest that has been met. Mr. Lawrence appears to be the only remaining minority member on the panel, and the state did exercise a peremptory challenge to remove him from the panel. The next part of the test goes on to provide that if the defendant satisfies this threshold, the burden then shifts to the prosecution to articulate a race-neutral justification for the disputed challenges, or in this case, the challenge. In this case, the state has offered two explanations, as I understand it, for the removal. The first one, and the primary one, is that the state believes that the juror was not truthful on juror questionnaire, specifically question 54, relating to whether or not, actually I don't have the questionnaire in front of me. Can somebody read me for the record the exact question? Attorney Fallon, sure. Have you, any family members, or anyone close to you ever been suspect in, arrested for, or charged with a criminal offense? He checked no. The court, okay, so the question required for the juror to indicate not only whether the juror himself fell into that category, but whether or not any family member fell into that category. Prosecutor, Mr. Fallon, indicates that the defendant or the juror answered that question no. That is not disputed. It also does not appear to be disputed that a gentleman with the same name, except senior, as the juror in this case, who is identified as junior on his questionnaire, has a record of a number of convictions in addition to the pending charge at this time. The state indicated that they attempted to conclusively determine whether or not John Lawrence with a criminal record was John Lawrence Jr.'s father. The age appears to match, and we now know that the middle initial also appears to match. The fact that one is senior and one is junior adds additional support to the argument that it appears to may well be the father. And because of that fact, the state argues that it has valid reason to, non-race related, to exercise a strike against Mr. Lawrence. The state also argues that based on his young age and lack of employment, that his commitment to the community may also be an issue in this case. So the court is satisfied that the state has articulated a legitimate race-neutral reason for challenging Mr. Lawrence. The application for the third part of the test was a point of dispute in Lamont. There was some dissent in that case, or at least one that I know for sure, by the Chief Justice, and I attempted during the break to review not only the majority decision but the dissent as well. And the court is satisfied that under the approach of either the majority or the dissent in Lamont, that the state in this case has met its burden. Specifically, I believe that while there is not a conclusive evidence, or the state did not come up with a conclusive evidence, it came up with some fairly compelling evidence to strongly suggest that the juror in this case was is the son of John Lawrence Sr. He has a criminal record, and that the answer given by the juror may well not have been truthful. The court cannot say conclusively it was not truthful, but there was certainly a good faith reason for coming to that conclusion that is not related to the race of the juror. Part of the rest of the outline by the dissent, which would apply, requires the courts to engage in a more thorough analysis or a stricter test, however you'd like to phrase it, and indicates that part of the court's duty is to assess the credibility of the prosecutor and the reasons given for the striking of the juror. In this case, I can find nothing, based on what the court recalls to be the demeanor of the state in questioning the juror or the reason given for the strike, that would suggest that anything was motivated by race. I believe that the reasons given by the state under the totality of the circumstances, and I'm not really aware of any other circumstances that would call their decision into question here. While it's true that under the Powers decision, a defendant who's not even a minority can raise the challenge, it's a little difficult to see applying the totality of the circumstances while the race of the juror in this case would have any special significance. There is no reason why, to the extent of the minority juror would be more sympathetic to a minority defendant. That would be a reason, an improper reason, for the state to attempt to remove him from the jury. We don't have a minority defendant here. But I'm certainly not basing my decision entirely on that, as I recognize, or as the case law indicates, the defense can raise the issues here. But to the court, it adds additional credibility to the state's argument that it made the request it did, or made the decision it did, on a race-neutral basis. I believe in the state's argument, and it emphasized the criminal record element of the father more than the second reason, but that's an additional reason for the state, which the state could have used. I'm focusing more on my decision on the reasonable grounds to suspect the untruthfulness on the questionnaire. So the court will deny the defense motion in this case. With that, is there anything else either party wishes to raise before bringing the jurors back? Attorney Beauty. Judge, just one thing real quickly I want to put on record in speaking with Mr. Gunn today. It appears there may be some confusion on what the court's order on the test of the samples for this EDTA or whatever. My understanding was that the state would preserve sufficient samples of the vial blood for any defense testing, and that would get sufficient sample of the actual RAV4 stains that were being tested by the FBI. Mr. Gunn was under the impression that any other stains in the RAV4 that had not been tested or that would be would satisfy that part of it. I just want to put it on the record that I disagree with that. I think the defense needs to have half of the actual stains that are being tested. Actual stains from the RAV4 that are being tested, and about which opinion might be given by the FBI. And I believe that was what we discussed in court. It's not clear in the hand or the written order, which was handed to me in the middle of the jury selection. But I think that's what we anticipated. The court. Mr. Gahn? Attorney Gahn. I would just state that I don't know if I'm disagreeing with Mr. Beauty at this point or not. All I know is that I do recall that we talked about splitting the blood vial evidence that there are 5 bloodstains from the RAV4. 3 of them were and of those 5, DNA testing was done, and each of the 5 showed to be the blood of Stephen Avery. 3 of those 5 have been sent to the FBI. The FBI may be taking one of those, and I will find that out hopefully before noon. They may be consuming one of them. They don't know. But I do know that my understanding of the order was that we preserved sufficient sample of the blood stains from the RAV4. I know for sure we have got 4 that are preserved. Whether one of them may be consumed, that's kind of up to the tester. So whatever, if it is, then I will ask him to find a larger stain, see if we can cut it in half, and I'll ask him to test that one too. I mean, I don't know if there's any disagreement here or not. The court. The focus of the argument was a splitting of the blood vial sample. I recall that. Attorney Gunn, right. The court. All I will say is I think it's important, if this line of examination is pursued, for the defense to also have an opportunity to perform testing on the blood that was found in the vehicle. Sitting here as a judge and not an expert on analysis of blood, I'm not going to be issuing orders on whether or not blood stain can be split, particularly a blood stain that can be split, because frankly I don't know if that's scientifically possible. The court's ultimate concern would be the element of fairness, and I think it's important that in some scientific fashion that both parties can get a chance to analyze the blood sample in the car to the extent that's feasible. Attorney Beauty. Well, Judge, I just want to be very clear on the record, because it is my understanding that I think it was clear before that in the order for fairness to be preserved here, it is not enough to say that we get some of the other sample. We need half of those stains that the FBI is going to be testing, because the EDTA levels will vary depending on where in the car, what the substrate is, fabric, metal, whatever. And that was a big issue in the Cooper case, and so that's why I want to make sure that it's clear that that's a concern for us here. The court. All right, let's do this. Mr. Gahn, you check with your folks at the FBI and see if it's feasible to split a sample of the stain or stains in the vehicle. If the parties still have an agreement, you can come back to the court, but I just don't feel I have enough information in front of me to address a difference of opinion, if there is one. Is there anything else before we bring the jurors back in who have been selected? And I take it that based on the court's decision denying the defendant's Batson motion, the jurors who were not selected can now be released. Attorney Strain. Yes. The court. Okay, very well. Janet, can you have them bring in the jurors? You can let Linda know the other jurors can be released. The clerk. They are not going to be in any order. The court. They don't have to. We can put 14 in the box and two extra in front. Wherein the jury panel was brought in. The court. You may be seated. Members of the jury panel, I'm going to address you that way because you have not been sworn as jurors yet. That will happen on Monday. I will be giving you some preliminary instructions on Monday, and one of them will include that what you just experienced, which is from time to time jurors may be excused from the courtroom for the court to hear arguments from the parties. For purposes of this morning's proceedings, in just a minute the court is going to excuse you for the day. But while you are back in the jury room, you will be receiving instructions concerning transportation arrangements for Monday, when the trial is scheduled to begin. If you have any questions concerning any of those arrangements, please pass them on to the bailiff. If necessary, they will be addressed by the court. Before I excuse you today, I want to again stress that you are to make certain that you have no exposure to any media coverage of the trial until you reach your verdicts in this case. As I have previously informed you, the jury will not be sequestered during this trial, but that decision is dependent upon your commitment that you will not listen to, watch, or read any of the news accounts of the case during the trial, nor discuss the case with anyone, including members of your family or other jurors. For these reasons, I'm going to order that for the duration of the trial, you simply not watch the local news on television. Do not listen to local news on the radio. Do not read the newspapers unless you first have someone remove the articles about this case from the paper. That is of vital importance. In addition, and I think one of the jurors brought up this up in voir dire, using the mute button, should a promo or something come on the TV while you're watching another show or anything regarding the case, please take those types of steps to consciously avoid any exposure to the case that may inadvertently be presented to you during the course of the trial. If you are inadvertently exposed to any of the information about the case during the trial, please notify the jury bailiff. At this time, I'm going to excuse you for the day, subject to the transportation instruction you'll be receiving shortly. Attorney Fallon, Your Honor, the one other reminder about the internet access as well. The court. Oh, I did not include the internet access, but that would also be exposure to the case, which is prohibited. Do not look at the internet for any information about the case. Thank you. Mr. Fallon? Jury panel not present. The court. Counsel, is there anything else before we adjourn to Chilton this afternoon? Attorney Strang, one brief thing, which is, given how long this ran this morning, I'm wondering if we could push back to 1:30 this afternoon. I have to get the materials for the hearing back in Appleton. The court. Okay, I do have one request. Do the parties have any idea how long they think the proceedings may take this afternoon? I assume there's going to be, or I was led to believe that there would be some evidence regarding the motion about the materials the state wishes to present during the opening. Attorney Kratz, that's the smallest part, Judge, the admissibility hearing on the demonstrative evidence. And Mr. Austin from the State Patrol will be available for a live testimony in that regard. We do have some other matters that, both as to opening statements and some other evidentiary matters. With my best guess, Judge, we should be out of there by, if we start by 1:30, by 3:30 or 4, if that would please the court. Attorney Strang, I'm guessing a little bit longer. I would have guessed that the computer-generated animation hearing between the testimony and the argument might go on for an hour and a half, maybe even 2, conceivably. And there will be some substantial discussion on the preliminary jury instruction. And I will try to catch up with counsel for the state before we get to that, just to see whether there's areas of agreement on the substantive part of the preliminary jury instruction. The court. Okay, all right. We'll see you at 1:30 in Chilton. Noon recess. Proceedings reconvened at Calumet County Courthouse. The court. At this time, the court calls State of Wisconsin versus Stephen Avery. It's case number 05-CF381. This matter is scheduled for a motion hearing this afternoon. Will the parties state their appearances for the record, please? Attorney Kratz. State appears by Calumet County District Attorney Ken Kratz, also by Tom Fallon, with the Department of Justice. Attorney Strang. Good afternoon. Stephen Avery in person and Dean Strang on his behalf. The court. All right. And we're here this afternoon, I believe, first to hear a motion filed by the defendant to exclude the use of computer-generated animations in the state's opening statement for the purposes of today. Is that correct? Attorney Kratz. Judge, the issue is the admissibility of the animations generally. There's a second issue that needs to be decided regarding images that would be used in the opening statements of both by the state and the defense. They are related in a sense, but the admissibility hearing regarding the demonstrative evidence generally and the computer-generated scene images, as well as the animation specifically, will need to be ruled on by the court this afternoon. The court. All right. Mr. Strang, it's your motion. I will let you add to that if you wish. Attorney Strang. Well, I agree with Mr. Kratz, and indeed, it is simpler than that. What we ought to deal with is just the admissibility of the computer-generated animations. Because if or to the extent they are admissible, then, of course, there's no objection to Mr. Kratz using the images from them in his opening statement. I say, of course, I guess that doesn't necessarily follow, but it is a fact here that if the underlying animations are admissible, I don't have a quarrel with him using a few slides from them in his opening statement, and he already has shown me those that he wishes to use. Attorney Kratz, I'm sorry, Judge. Just to complete that point, there is a more global question, though, if there are any other objections to the images that I have proposed in the openings. I just simply wanted to make a record of that before Monday, otherwise we're ready to proceed. The court, all right, you may proceed. Attorney Kratz, Judge, I have heard at least from one member of my staff that at least the court's microphone isn't picking up very well in the house. This is probably a good opportunity to set the volume levels and the like. We can do that during the hearing, of course, but I at least wanted to alert the court that it's a little quiet, at least for the house, the people behind us not being able to hear very much. The court, my recollection is that somewhere there is a remote control device around here that allows me to control the volume, but I'm not sure where it is. Sheriff Poggle, 1 should be yours, 2 the clerk's, 3 is 4, and 5 should be Attorney Kratz. 1 is the bench. The court, number 1 is the bench. Attorney Kratz, that's much better already. The court, is that satisfactory? Attorney Kratz, perfect. The court, wonderful. Attorney Kratz, thank you, Judge. The state will call Tim Austin to the stand. Attorney Strang, while Mr. Kratz is setting up, there was an issue Mr. Fallon suggested, which is keeping the media cameras off the laptop screens of counsel for both sides. I don't know if that's already been covered by the media or if we need to address it. The court, I don't have a copy of the media order in front of me, but I know it referred to materials that the counsel use on their table, and I will indicate today that if the order as written does not specify images on laptop computers, it's meant to apply to all material on the table, and that specifically includes laptop computers. Attorney Kratz, Tim, the clerk, raise your right hand. Trooper Timothy Austin, called as witness herein, having been first duly sworn, was examined and testified as to the follows. The clerk, please be seated. Please state your name and spell your last name for the record. The witness, my name is Timothy Austin, Austin. Attorney Kratz, Mr. Austin, if you could pull the microphone towards you, would you once again state your name for the record? The witness, yes, sir. My name is Timothy Austin. A direct examination by Attorney Kratz. Mr. Austin, how are you employed? I'm employed as a trooper with the Wisconsin State Patrol. How long have you been with the state trooper? Been a state trooper. I have been with the patrol since July of 1996, about 10 and a half years. And do you have any specific responsibilities with the state patrol? Yes, I'm assigned to the Wisconsin State Patrol Academy to the Technical Reconstruction Unit. Mr. Austin, have you brought with you here for a document which is known as Circulum Vitae? Yes, sir, I have. And for the lack of a better term, is it common knowledge that this kind of document, called a resume or something like that? Yes, they are. Essentially outlines my training and experience in the field of reconstruction activities. I have handed you what's been marked as identification as exhibit number 1. Could you tell me what that is, please? Yes, sir. This is a document you referred to. It's my Circulum Vitae that goes over my education, training, certification. At least for purposes of this hearing, if you could just briefly indicate whether or not you have specific education, training, and experience that permits you, on behalf of the State Patrol, to create images for not only use for the investigative purposes, but for the use in court proceedings. Yes, sir. I hold certification as an instructor in the field of forensic mapping and the use of total station technology for the collecting measurements as scenes. Mr. Austin, in this case, were you asked on behalf of the state of Wisconsin to assist in the creation of images at or near the property known as the Avery Salvage Yard? Yes, sir. I was contacted to provide forensic mapping services, ultimately leading to the creation of scale diagrams and three-dimensional models. When did you first become involved in this case? Without referencing my notes, I believe it was November 5th, 2005. The same day that law enforcement personnel took control of the Avery property, executed search warrants, and otherwise began their search efforts. Is that right? Yes, sir, that's correct. It was late in the afternoon on that day when I was contacted. Mr. Austin, did you then spend time on the Avery salvage property itself, and did you in fact take some measurements and perform other duties which allowed you to create these images? Yes, sir. For the next approximately 7 days, myself and a team of law officers forensically mapped and measured the entire salvage yard property. To assist the court and counsel, I'm providing your testimony today. I'm going to have you refer to the image that has been portrayed on the screen. Can you tell us what we're looking at, please? What you're looking at is an aerial photograph that I believe was taken by the State Patrol pilot, Trooper Dennis McConnell. It shows the Avery salvage property referred to before and some of the surrounding properties and the landscape. Now, so the court understands where some of these images are going to be coming from, you provided counsel, that is, the prosecution and the defense, as well as a copy for the court, some figures or images that ultimately have made its way into the binder of yours. Is that correct? Yes, sir, that's correct. This is one of many images that I put in a document entitled Forensic Mapping and Scenery Construction Report. To complete the record, Mr. Austin, I have handed you what's been marked as Exhibit Number 2. Can you tell us what that is, please? Exhibit 2 is a DVD containing my narrative report, digital photographs taken by myself and other State Patrol officers, and other logs documented by the State Patrol. Essentially, the binder I described before is what's on this DVD. All right, did you bring that binder with you? Yes, sir, I have a black and white copy. Can you just hold it up for us and show us what you're talking about? This binder here is the one I'm referring to. So, Exhibit Number 2 is a electronic version of all the information that's included in that binder. And again, the relevant portions, other than some of the measurements and the like, but at least the figures that you will be referring to have all been provided to counsel and court. Is that your understanding? Yes, sir, that's correct. Attorney Kratz. Okay, so that I don't forget more than anything else, Judge, I am going to move for the admission of Exhibits 1 and 2 at this time. Attorney Strang, no objection. The court. All right, those exhibits are admitted. I have one question. Or maybe it's still coming, has the image that we're looking at on the screen been identified in some fashion? The Attorney Kratz, it has not, Judge. It's about to be. The court. Very well. Go ahead. Attorney Kratz, Mr. Strang indicates, Judge, that my mic should be up a little bit as well as Mr. Austin's. That's probably the time. Sheriff Poggle, I think there would be for Mr. Austin. The court. And the state should be 4-5. Attorney Kratz, mine says mic 4 underneath, Judge. Attorney Strang, mine is mic 5. The court, I'm hearing some type of buzzing periodically. I don't know if it's something over the sound system or where, but it's not bothering. If it's not bothering the parties, we'll proceed. Attorney Kratz, I think what happens, Judge, is with this sound system, when you talk, as you might know, the microphone's cut out. When the court talks, they don't want anybody else talking at that time, which is probably a good idea. But I think the system then picks up yours if we overlap a little bit, and I think that's what's causing that, but we'll move forward. Question by Attorney Strang, or by Attorney Kratz. Mr. Austin, are you able to then, with the image that we're referring to here, are you able to find that figure, and could you please identify that in your materials? Yes, sir. May I reference to my binder? Please do. If I may, sir, go ahead. That photograph is figure 3, which appears on page 10 of my narrative report. So at that scene that you have identified as the Avery salvage yard, then, I think you began telling us that you took some measurements. Can you tell us about that? Yes, sir. The bulk of the measurements were taken using an electronic device called a total station that's made by a company called Geodimeter. Can you spell that for us? Yes, sir. Dimeter. What is total station? Total station essentially is an electronic device. It measures distance and angles to document an object's position in 3D space. Basically measures along an X, Y, Z axis on a standard coordinate system. What is a total station typically used for in your line of work, if you understand what I'm asking you? The total station, we utilize that in the reconstruction unit for taking measurements at both crash and crime scenes. You mentioned that total station assists in taking measurements. Can you very briefly tell us about how that occurs? Are you asking me how the instrument works or how it records measurements? Sure. Essentially, the instrument locates itself, if you will, in 3D space. And then, if I'm taking a measurement to you, Mr. Kratz, the instrument recognizes that it's going to say, turning 90 degrees towards you, an elevation of maybe down 2 degrees. The instrument recognizes that change in elevation or change in angle, and then assigns or calculates what your coordinates would be in a relationship to me. I see. So it isn't just simply a tape measure to me, to you. That would be one axis, if you will. It's actually a three-dimensional measurement that's being taken. Is that correct? Yes, sir, that's correct. So in lay terms, is that even more accurate than a tape measure or a one-dimensional measuring device? When you look at adding in the operator factor, if you will, yes, the total station is going to be more accurate than if we had strung out, 1,000-foot tape of the Avery salvage lot. All right. How many days were you involved in taking measurements at the Avery property? May I again reference my notes? Sure. Attorney Strain, the witness ought to feel free to look at whatever he needs, whenever he needs. The court, very well. The witness, thank you, sir. We began the mapping on November 5th and finished the mapping on the Avery property on November 12th. So that was really the entire time the law enforcement had control of the property. Is that right? Yes, sir. You mentioned that during that time frame you were involved in taking these measurements individually. How many of those days were you personally out there, if you remember? I believe that I was there for 6 of those 7 days. And during that time, Trooper Austin, do you know how many individual measurements were taken through and by the use of this total station process? Yes, sir, there were over 4,100 measurements taken at the Avery salvage yard. I assume, based upon what you know of the total station and your use of the certifications for that piece of equipment, you have an opinion as to its accuracy. Yes, sir. My opinion is that total station is obviously very accurate. In fact, the maximum induced error that an instrument gives us is only about 3 seconds. To explain, a circle is divided into 360 degrees. Each degree is divided into 60 minutes. Each minute is divided into 60 seconds. The total station is accurate within 3 seconds. Essentially, in this particular case, our longest shot was about 1,200 feet. That comes out to be an accuracy of less than a half an inch. After the measurements are obtained by you and after the data is compiled, could you tell me the first step in the creation of images? And let's first talk about two-dimensional images. Certainly, the total station scores its data internally in its onboard data collector. We download the data from the total station and we bring it into a computer-aided drawing program. In this case, we use a software program called CAD Zone to begin processing that information. I'm going to once again direct your attention to the in-house screen. We have come up with a better name for that as we go through the trial. If you could tell me what figure we're looking at here, and if this is an image that may better describe a two-dimensional drawing or representation that's created. Yes, that particular picture, if you will, you have on board is figure 4 from my narrative report. What this shows is a two-dimensional view, meaning it is a straight or completely orthogonal looking straight down on this portion of the Avery salvage yard. I'm sorry, do you have a laser pointer with you? No, sir, I do not. I'm going to give you mine. Thank you. Trooper Austin, please feel free to use that as you're describing things so we can better understand what you're talking about. Go ahead. Sir, if I may, do you have figure 5? It might be easier to help explain this. I'm sure I have everything. What I've asked you to do is essentially to zoom out and look at the entire Avery property that was diagrammed and mapped. The portion you showed us before, which was figure 4, is a close-up of this upper northeast corner, which is the primary business buildings, if you will, for the Avery salvage yard. So if you want to go back to figure 4, at least we know now that portion of the main diagram it is from. So now we essentially zoom in on that northeast corner, and we can see this would be able to the main road coming in. This is a gravel driveway, if you will, that runs east and west. Here's a storage building, the main shop, and here's a private residence. So we have taken a small portion of that area that was mapped, and now looking at our diagram straight from above, looking down at a specific corner of it. Now, the diagram like this, the two-dimensional diagrams, is what they're commonly used in trials or triers of fact to help juries or judges understand the evidence. Yes, sir. We commonly use two-dimensional diagrams such as this to help show the scene or show where the objects are or distances of particular items. Although this is much nicer, the concept really isn't any different than a blackboard or a chalkboard that might be used to help describe or help understand some evidence. Is that fair? As technology has evolved, we have moved from the chalkboard to the easel to two-dimensional diagrams. As technology continues to improve, we're going to move ahead also. Let's move ahead today then. After your two-dimensional images were created, are you able to then, with the total station and the measurements that are gained therefrom, create three-dimensional models? When I discussed the total station a few questions ago, I mentioned that the total station measures in 3D space. That's the x-coordinate, y-coordinate, and now the z-coordinate, which gives us a height or elevation to the objects. So we have information there, just that now we bring that data into a second computer program. This one is called Forensic 3D, which allows us to draw or create diagrams in 3D space. So we can add that height, elevation, and elements to the object. I'm going to once again direct your attention to the screen and ask if you can tell us what this figure is, what it shows, and how it helps to explain your process. This is figure 8 from my narrative report. It's on page 14. This shows an unrendered three-dimensional image. And when I say unrendered, what I mean is it does not have any textures applied to the three-dimensional surfaces. As you can see, our garage building, our vehicles are white. They essentially haven't been painted, if you will. I haven't applied any type of textures to those objects. The application of the texture, then, how is that process created? In many cases, the software will allow us to take a photograph of a particular texture. What I mean by that, if I was diagramming this desk, I could take a photograph of the wood and paste that wood or photo of the wood on the model. In this case, in this particular garage, we photographed the siding of that garage that we could apply to our three-dimensional model. And so you don't only guessing what the different colors and the different textures of the objects are, but you take them from the images that you retrieve from the property. Is that right? In most cases, I don't like the word guessing because there are some of that I did apply textures from a personal library. For example, the paint on the truck. I did not photograph the paint on that particular truck. I applied a general black car paint texture to it. What we do see on the garage. By the way, what figure are you referring to now? I'm sorry, this is figure 9. It's the same image, however, it is now being rendered in the software. Again, what do we see here, however, is the texture mapping process on the garage building. Your three-dimensional modeling, could you describe, not just in this case, but in other cases where you have been asked to testify In other cases that your colleagues have been asked to testify, what is the advantage of 3D modeling versus two-dimensional images that we saw, as a jury or a trier of fact may consider? When we look at a two-dimensional image, again, we're just looking straight down on that particular area. What's difficult for us to appreciate any type of spatial relationships or a geometric perspective, if you will. In other words, we don't know, or it's more difficult to actually visualize how that scene looked or how objects are related to each other. When we now take that photo into a three-dimensional model, we can get a better understanding of how that scene looked or how that objects are, again, in a relationship to each other. All right, you were asked then by the state by the prosecution to take these 4,100 plus measurements, all of the data, including all of the photographs that you both obtained and viewed, and created some modeling for us. Is that right? Yes, sir. I have to add, though, we did not model the entire Avery property in 3D. Why not? I think I would still be working on it today if I modeled that in 3D. All right. Also, the work that I did was under the direct supervision of the lead investigators or yourself, and it was determined that we probably really didn't need the entire property done in 3 dimensions. Now, because this is an adversary system, in other words, because there's the defense and the prosecution, it's typical for one side or another to ask you or direct you to create images for use at trial. Yes, when you look at the work that I did, and I know we're going to get deeper into this, but there are evidentiary areas that I don't necessarily know about, and I need that guidance for persons to tell me what is important and what is not important in a diagram. It's very typical for one side to tell me what they would like to see. Many of these exhibits I designed to assist others in explaining to you or to a jury what is that they did out there at the scene. Let me just talk about that just briefly. So other than just showing you, if you will, or being able to show the jury the scene itself, did we ask you to provide or create images to allow investigators or law enforcement officers that found evidence or even other experts to use those images to better explain or describe the evidence that they may have found or their testimony? Yes, sir. It's one of the things we're to be able to do, if you will, sit in this box and verbally explain where something was positioned. But to be able to physically show that geometric relationship, in other words, where it was compared to other objects, helps a person to better understand where these items are located, where they are in relationship to other items. Let's talk about some interiors first, all right? And you were asked to do some modeling, not just in the yard itself or in the exterior, or is it easier to talk about exteriors first? It's your option, sir. Doesn't matter to you, I'm sure? All right, let's talk about some interiors. I'm going to show you figure number 31. Let's talk about what we're looking at here first. Sir, this is figure 31, found on page 32 of my narrative report. What we're looking at here is an overview of a residence that was on the salvage property. And what I've done on this particular model is I have hidden the roof. In other words, if the roof is a layer, I turned the roof off so that we can see all the rooms together. Let me just stop you there. I'm sure Mr. Strang and I at some point will establish the foundation. But Exhibit 31, we're looking at Stephen Avery's residence. Yes, sir. All right, go ahead. Again, what I have done is taken the roof off, or rather hidden the roof from the model, so that we can look at all the various rooms that are inside of his residence. If you remember the old overhead projectors, if you could lay one piece of plastic over it and another, essentially we've taken off one thing, we've taken one off so that we can see what's underneath the roof in this case. Now, figure number 31 is unlabeled, or a clean, if you will, image. Were you also asked, and did you provide labels if the court allows, and if the state or whatever party actually wishes to present them, believe it would be helpful for the jury? I provided you with 2 separate images, one being unlabeled, which we just saw on the screen. I also provided you with one having labels. In other words, there's text and leader arrows identifying various rooms. What are we looking at now? This is the image I just described. It is the same one you had previously. However, this one has text and leader arrows showing various rooms in the residence. And although all the images, in fact, I'm going to have you look at, I think it's exhibit number 4. You have a packet of images up there. Could you tell us what exhibit 4 is? Yes, sir. I believe these are those images that I provided you with. They are 4x6 prints of the rendered models, and there should be labeled versions and unlabeled versions in those envelopes. And for assistance of the court and really trying to anticipate what the court's direction may be to me, to the state, in use of some of these items, you have created a hard copy or a set of all your figures, both labeled and unlabeled, so that a record can be made. That is, if some of the documents and some of the images might be introduced and some may not, we're able to just put in ones that are acceptable to the court and perhaps the council as well. Is that right? Yes, sir, that's correct. Attorney Kratz, just to complete the record, Judge, although we will have originals, the entire packet which has been provided to the court in a 8.5 by 11 form, all those images are in exhibit number 4. I would ask the court to receive those for purposes of the record at this time. The court, any objection? Attorney Strain, none. The court, those are received by Attorney Kratz. Now, other than the buildings, including Mr. Kratz's trailer, were you asked to do some interior renderings of Mr. Avery's garage? Yes, sir. And could you tell me, if we look at one of those figures, direct me to one that might be helpful? Exhibit 41? Yes, sir, Exhibit 41. I'm showing you what's been labeled then as Exhibit 41. What are we looking at? Sir, Figure 41 is an overhead view of the garage that you asked about. And again, I hid or turned off the roof layer so we could see what's inside of that garage. I'm sorry, this is Figure 41. It might be from Exhibit number 2, if I'm remembering correctly. Why don't you take the laser pointer and just very briefly tell us the items that you have been asked to place inside of that garage. Inside of the garage, there's a Suzuki Samurai vehicle that was in the garage when I completed the forensic mapping of that location. Next to that is a snowmobile. There's also a snowmobile on the opposite side of the Suzuki Samurai. And then around the border, around the walls here, there are various tools, if you will. There's a tool chest in the back. There's an air compressor. Next to that is a welder. There's a freezer and a filing cabinet in here. Various larger items that we can use to locate anything else we need to find in the garage. Let me ask you, Trooper Austin, without the assistance of this computer-generated image, would a jury or a trier of fact ever be able to see something like this? Attorney Strain, that really is not a proper question. Attorney Kratz, I can ask it a different way, Judge, perhaps, Judge. The court, go ahead. By Attorney Kratz, the computer-generated images, does it allow anybody, not just a trier of fact, to anybody in the courtroom to visualize a scene from an angle or from a perspective that the human eye could not? That's why I believe that the three-dimensional models are important. In this case, we would never be able to have an overview of the garage or interior without removing the roof as we did in the three-dimensional model. The same with the house. And we can then move about in this model to gain other perspectives so that we can, perhaps from a different viewpoint, look at those spatial relationships we discussed earlier. When we're talking about three-dimensional, it is that relationship that is the relationship between a piece of evidence to a fixed object or to a known location that's important. Is that what your testimony was? Yes, sir. All right, let's talk about the exteriors for a moment. I'm going to have you look at figure number 10. Tell us what we're looking at. Figure number 10, Mr. Kratz, is an overview of the entire area that I did model in 3 dimensions. Does that include what would be known as the Stephen Avery residence and curtilage, as well as the Jonda and Dassey residence and the surrounding area surrounding? In previous slides, we looked at a residence and the interior, and that Stephen Avery residence is over here. The garage we looked at is next to that residence. In terms of directional relationship, in this particular view, north would be to the bottom of the screen. And yes, I'm sorry to finish your question, sir. The Biochemistry residence is over there, here, on the left side of your screen, and her garage. I'm going to have you look at just a couple of other images. Image number 16. Yes, sir. Figure number 16 is also from my report. Essentially, we have moved our camera to get a different perspective of the Stephen Avery property. This allows us to see both the residence, the garage, as well as some other items that I was asked to include in the model. Were one of those items or two of those items that we're going to talk about, first of all, the van, the Dodge Caravan, I believe, is that shown in this image? Yes, sir. The Dodge Caravan is the red colored vehicle down here in the lower left portion of your screen. For the court's information, and just by the way of offer of proof, the evidence in this case will be that it was the vehicle that Teresa Halbach was asked to come and take a picture of. Were you also asked to include a burn barrel that was found or that you took dimensions of and measurements of on this property? Yes, sir. Both the minivan and the burn barrel were in place when I did the forensic mapping, so they were located with the total station. The burn barrel you're referring to is over here on the right side of your screen. And not going into any detail because that's what the trial is for, but was it your understanding that there was some evidence that was recovered from the interior of the burn barrel? That is my understanding, sir. Now, as I understand, you're able to move the camera around, if you will. Figure 20 is an example of that. Can you tell us what we're looking at? Sir, that is indeed figure 20 from our narrative report. What we have done from that previous slide you had up is we have moved our position further to the south. And now we're looking at the northwest to the back of the trailer. I'm sorry, the residence we discussed before, and to the back side of the garage, and items that were identified to me as being of evidentiary value, that being the garage, being behind that garage. Although figure 20 shows some of the same items that figure 16 would be, this is a different angle, and again, something that the human eye would not be able to accomplish. Is that correct? And we're moving in closer from that last point, which allows us to see items in a better or greater detail as they have been modeled here. So yes, I do agree with you. Last example I'm going to give you, and again, these are just by way of example, figure number 23. Tell me what we're looking at. Sir, this is figure number 23 from my narrative report. We have moved further to the southeast where we were before and looking back side of Stephen Avery's residence. We're now looking at the backside of the Biochemistry residence and some other items back here that I was asked to include in the model. All right, Trooper Austin, this is a little bit out of your area of expertise by crash reconstruction and crime scene reconstruction. Were you asked to assist another expert, an anthropologist in this case, in creation some other images? Yes, sir. I was asked to work closely and under Dr. Leslie Eisenberg to create additional model images. Were you able to perform that task? Yes, I physically met with Dr. Eisenberg in Madison and had a lengthy communications with her after meeting with her in person to create model images that would help her explain her findings in this case. Now, I don't expect you, in fact, to just let me ask you much of what you were asked to create. Did you know what it was that you were creating? I'm not sure how to ask that. Why didn't you tell us how that process was culminated? Yes, I was asked to create the model, which is my area of expertise. However, what she wanted me to assist her with was creating a skeletal models so that she could point out locations of various bones. That is certainly outside of my area of expertise. That's why I worked closely with her and directly under her so she could explain. I would like to, like a leader, arrow pointing to this bone, and this bone is called A, and the name of the bone. All right, I have a figure on the screen. It's just a a picture of a female skeleton. We're not going to show these because that will be Dr. Eisenberg's area of expertise, but could you just briefly describe how these skeletal models were created? The base of the skeleton model, that would be the one without any type of textures to it, I obtained from the FBI in Quantico, Virginia. They sent me a CD containing various skeletal models. I chose the female skeleton as the most appropriate in this case. I then applied a bone texture to it. I've received approval from Dr. Eisenberg, and then met her in person to again show close-ups or different bone locations on that model. All right, and again, those have been created, provided to the court and to counsel, and are included in your images, both exhibit number 4 as well as exhibit number 2. Is that correct? Yes, sir. They are on the DVD I've provided to you, and they should be in the photographs also, or the 4x6 images rather. All right, let's leave the scene mapping or modeling, and then let's talk a little bit about animations. Were you asked to create animations as well? Yes, sir, I was. And could you tell us about that process, please? To create motion, essentially, we need numerous still images of those still renders. In fact, we need about 30 of them for every second of motion that we want to create. If you were to think back perhaps to a child's toy, where you'd have something in the corner and flip through those pages, we see the object changing or going into motion. That's the kind of thing we're doing here. We're putting image after image after image to create the effect of moving through a scene. Now, in lieu of, or instead of taking the jury the Avery salvage yard in the middle of the February, did I ask you to create a walkthrough, or if you will, of the Avery property, the Barjanda property, and the surrounding curtilage? Yes, sir, you did. And I know that we showed the court your first draft of that. It was probably last week sometime. Have you made some improvements to that? Yes, sir. I have made some minor changes to that. I have given you another exhibit. I think it's exhibit 2. Is that right? Exhibit 3. Is that right? Yes, sir. Tell us, what is that? Exhibit 3 is the disc I gave you maybe an hour or so ago with the final version of the animations. The court. And for the record, Judge, I have given Mr. Strang his own version of that, and I will be asking the court to accept exhibits 3. Have I moved exhibit 4? Janet, do you know? The clerk. Yes. Attorney Kratz. Yeah, exhibit 3. Then I would offer at this point to complete the record. The court. Any objections? Attorney Strang. Not for purposes of this hearing. The court. That exhibit is admitted. As I play this animation, Mr. Olson, or let me ask you this first question. What improvements did you make, and how long did it take to create, and what kind of process was involved? The version I gave you last week, my draft version, was completed at 15 frames per second, meaning there were 15 images for every second of animation. I felt it looked somewhat choppy. I therefore re-rendered it to 30 frames per second, which gives a much more fluid sense of motion, if you will. I also felt that that in that draft, the gravel did not appear as it should in the animation. Because of the way the software looks at the reflection of light, the gravel essentially appears to sparkle. I therefore changed the gravel texture so it doesn't have that reflective capability to it. Once again, this animation, as well as all the other still images, you believe that they will assist not only as a trier of fact that the jury, but other witnesses in explaining evidence that's found, or relationships between that evidence and fixed objects. Mr. Kratz, as we put these 5,200 pictures into motion, or make them give the impression of motion, that's going to help myself, you, jury members, to be able to again see where items are located to each other as we go from one end of the scene to the other, or then back around to the backside, if you will. We're going to get a better understanding of what exactly the geometry is of that particular property. I'm going to play this DVD that's been created and just invite you to chime in, if you will, when it becomes appropriate. Attorney Kratz, the record should reflect, Judge, that this is Exhibit 3, and I've asked Mr. Austin to narrate as we go through. Go ahead, Mr. Austin. Mr. Kratz, what I've done, I started at the southeastern portion of that property, if you will, and we're going to come in by one of that Dodge Caravan, which was talked about before, was identified to me as being of evidentiary value. We're then going to pause in the front of the caravan and identify it using a leader, a beater, and that is a Texan arrow. Between this rendering and the one last week, did you also remove some things? I did change some of the text, and I'll bring that up when we get to that point, what was changed from the previous version. All right. Forgive me, I did not forget to tell you this. I did forget to tell you this earlier, sir. Another change I made is I slowed down the camera as we pan across the top of the residence, so you will see it slightly slower as we move from room to room. Moving from the caravan to the Stephen Avery residence, what we'll see is we'll fade that roof out so we can see the interior of that residence. Now, as we move between these rooms, this is one of the changes I made. It's a little bit slower than what you saw last week. And we're looking at all these images, how many separate images that we're actually seeing. There's over, for the entire animation sequence, there's over 5,200 images that were rendered to create this. How long did it take to create this? I utilized 3 separate computers to try and speed up the process. I started last Friday and I finished last night. So any delay wasn't intentional on your part. No, sir. Moving from the residence to the garage, similar to the still image you showed us before, Mr. Kratz, we're going to fade the roof out so we can see the inside of the garage. If you haven't added any images, all these things that we're seeing were there while you were taking the measurements. Is that correct? That's correct. From here, Mr. Kratz, we're moving from the overview of the garage. We put the roof back on, if you will, and now we're looking at the items behind the garage. And I have added, these were in last week's version. I have added labels identifying Stephen Avery residence, and we see we are now at the Stephen Avery garage. The darker area to the left, would that be what is known as the burn area, or where some other very important items, including some bone fragments, were found? Yes, sir, that's my understanding. We're now moving to the southeast. We're going to go behind the Biochemistry property, and we're going to identify that residence as well as the burn barrels that were positioned behind that house. Those burn barrels were there. I did the forensic mapping, so those have been, their location was mapped. This is one of the changes in the text. Previous to today, that said Jonda burn barrels. I have taken the name off, so it just says burn barrels there. Some other witnesses may identify who actually had control of those burn barrels. Was that your reason for the change? Yes. From those burn barrels, we're now moving back to the front of the Stephen Avery property, and we're going to show the geometric location of the burn barrel position there. And again, when we show the text here, this previously stated Stephen Avery burn barrel. Now it just states burn barrel when she showed the header. And this is essentially the end of the animation generated here. We have seen those images, as I discussed before, those 5,000 images, and we're fading out to close off the animation. Now, this afternoon, we're not going to show the skeletal animations, but it was roughly the same process used to assist the jury, ultimately, and probably through the narration of either an anthropologist or a pathologist with what they believe is some important evidence found in this case. Yes, the second animation you're referring to was generated in exactly the same manner. It's not as long. They're only slightly over 600 images to generate that one. And I don't know if you viewed that one last week. If you did, there were no changes to it at all. That one was not altered in any way. And finally, Mr. Austin asked a little different way, perhaps in a more technical jargon. Are there images that you created, these computer-generated images, true and accurate depictions of the items that you portrayed within them, at least to the best of your ability to create them? Yes, sir. All right. For the purpose of this admissible hearing, that's all I have, Mr. Austin. Thank you, Judge. The court. Mr. String. End of part 1.